So I've just hit record to get this recorded for posterity online. Welcome everyone. So this is our first Innovators Toolkit session of the year. So we're thrilled to have you all with us for this session on scaling social enterprise and legal basics for scaling social enterprise with Kevin Christopher. So thank you all for being here. My name is Ben Soltoff. I am an Environmental Innovation Fellow with Tsai CITY. So my role focuses at the intersection of all things environment, innovation, and entrepreneurship. My role is split with the Center for Business and Environment at Yale, and this session is a collaboration between CBEY and Tsai CITY. So we're really excited to start off the Innovators Toolkit series with a joint CBEY-City collaboration in recognition of the many ways that innovation is connected across campus. So I'm gonna turn it over to Kevin pretty soon, but just first to give you an overview of this series. If you're new to it, Innovators Toolkit is a series to share practical skills across all areas of innovation and entrepreneurship. It's totally open to the public. So we try to make the barrier to this as low as possible, and all the workshops are free. And the idea is that we deliver skill building that can apply to a venture, to a nonprofit, or whatever it is you're building, whatever it is you're innovating. So in the following session, you're going to get an overview of some basic legal concepts for starting something new. You are going to change your whole concept of the letter B. You're going to learn about a startup that changes your view of what happens in the bathroom. And you'll also just fundamentally reconsider the very role of a corporation in society. And so I've just written a big check for what's gonna happen in about an hour's time, maybe a little extra time for Q&A. And I'm very lucky that I'm not the person who has to cash that check. That person is Kevin Christopher from the Rockridge Law Group. And now I'm gonna turn it over to him to get started with the presentation.
All right, thank you so much. So I am going to share my screen here. There we go. Let me just get some chat function here so I can see if anybody has anything. I am very honored and excited to be here today in this sort of COVID era living room talk type series we have. I'm coming to you from Tennessee, the thriving corporate social responsibility state of Tennessee. We'll get into that a little bit. One of the reasons why I am presenting to you is because I am leading a law firm that is a B Corp law firm and am one of the founders of an initiative called B Tennessee. So it's kind of like a B local in the state of Tennessee. It's an initiative to encourage corporate social responsibility, to advocate for triple bottom line business models, whether they're B Corps or similar models, and to really encourage more mission-oriented business in the Southeast, which that kind of conversation is a little bit out there. It's a little bit liberal, sometimes dangerous. Historically, companies in Tennessee, they may be very charitable. They may have particular things that they do that fits within what we commonly think of as corporate social responsibility. But this idea of a holistic business that takes into account all stakeholders, social impact, environmental impact, investors, and making profit as well is doing something productive in the world is something that's sort of new to the Southeast. You see a lot more of these types of models on the coast, up where you are in larger metropolitan areas. So that's a little bit of the reason why I'm here presenting to you today and have the opportunity to talk a little bit about my experience and my perspectives on social enterprise. I am a patent attorney and a founder. I relocated to Tennessee from the Bay Area in California, where I was involved in renewable technology, biotech. And so I have been in your shoes before, if you're innovators and founders, in developing startup companies, scaling them, working with investors, building teams, whether it's in the energy space, the life science space, or consumer product space. This slide is basically a fancy way to say we're a law firm. Here's a legal disclaimer. If you've ever seen a presentation by a lawyer, you can expect to see something like this. Basically, in a nutshell, if you're riding around on a scooter and watching this on your phone, it's dangerous. You might get hurt. Don't come after me. All right, so now that's out of the way, let's talk a little bit about sort of the roadmap of where this is going. So today we're going to talk a little bit about benefit companies and B Corps as social enterprise models. Lots of different models out there. I'm going to focus mostly on that today. We're going to have a little bit of intellectual property and then some practical tips that I'll offer from the perspective of both an attorney working with entrepreneurs and an entrepreneur myself. So let me just start off high level saying there's some problems with corporate social responsibility when it comes to creating a CSR business. So as an example, some of the things that we're seeing right now, as lawyers, we are required to basically, for our business clients, provide them with the best models for success. We provide guidance according to the laws that are out there. And so one example of this is in the click wrap space. So a lot of you have signed up for services where some terms and conditions will pop up on your screen. You all see that it's fine print, it's legalese, lawyer talk. We just kind of scroll down and hit, yeah, okay. Oftentimes that language might have embedded in it a hyperlink to a landing page where those terms regularly change. And as part of that, you might have an automatic renewal. And all of this is governed by an arbitration clause. So this is perfectly legal and perfectly fine for a business, and something that on one hand, we should encourage businesses to do, right? Provide some sort of SaaS where it's really, really hard to get out of it. That's automatically going to renew for another year or 2 years at a high price point. If you try and dispute it, you really don't have much leverage because you have to go to some place in Wisconsin to arbitrate it. So you're kind of stuck with it. And so, you know, is that really being socially responsible as a company? Maybe, maybe not. That's really just about a product. At the end of the day, it's not really all that different from a t-shirt that you might be selling that you're marking up 10 times. And then there's always the cliche do-gooder solar company. You know, and we get this all the time. I make something that's really good for the world. I make solar panels. So what do I need to do to register as a B Corp? And so there are problems when you try and focus the conversation of corporate social responsibility just around what a company sells, produces, or how it engages with its customers. And that's really where the legal structure of benefit corporation comes into play. Now, when I moved from the Bay Area to Tennessee, I bought a 100-year-old farmhouse and rehabbed it. And as part of that rehabbing, I tore a lot of it down, built it back. There were walls that were sort of covered in newspaper, and these old newspaper from the early 1900s. And I saw these advertisements for snake oil and other things. And that's kind of what this quote reminds me of. Jack Welch, who gets a lot of reference points for his statements around shareholder primacy, 20 years after some of these statements said, look, this is actually the dumbest thing in the world. Why did we do that? Shareholder primacy in itself is basically the idea that as a corporation, your primary goal is providing value in return to your shareholders. Some legal scholars will argue that this doesn't really exist, or people like me are making too big of a deal of this. But it's a thing, and it has arisen over decades of the practice of corporate law, and most companies are required to operate in this way, or they risk derivative suits if they're not making decisions according to what's going to produce the maximum return to our shareholders. then they might be sued, they might be fired, they might be replaced as officers or directors. The practical application of a corporate legal system like this is you end up with companies making near-term decisions all about profits. They're not really investing in the company as a culture, as a long-standing thing, investing in the community. And so because of that, we have come up with a way to sort of fend against that. And the evolution of shareholder primacy was really a confluence of factors. But because of that, you see this exploding CEO pay compared to the wage hour workers, the minions now compared to these executives and directors. Just looking at some of the models that historically the pay versus the productivity gap, for decades, they were pretty closely related. But since we've developed this system of shareholder primacy, you have productivity rising, but hourly compensation is not. The executive pay is what's rising, and shareholder return. So the model benefit corporation legislation is basically a legal framework where you as a founder, if you're idealistic, if you care about certain things, you want to grow a business that has certain employee programs in place, benefits in place, you care about the environmental impact of your business. All of these things go into your corporate structure now under a benefit corporation statute, where you can make decisions according to what you care about and be shielded from derivative suits, from downstream investors who want to shake up your company, shake up your ideas. We don't want to do any more of that one-to-one stuff. Why are we giving away product? Why are we giving our employees a year out of the company to work from home? Why are we doing all these things? It's hurting our bottom line. And so the first benefit corporation statute was adopted in Maryland in 2010. And since then, this has spread to 40 states that now have some aspect of benefit corporation statute. So that alone tells you that, hey, this thing is really resonating with people in both left-leaning and right-leaning states, that there is an interest in having some sort of structure that allows companies to operate with some sort of mission orientation or environmental or social focus to how they operate. So what exactly is that? I mean, so if you're looking at a benefit corporation statute, what is that all about? How does that flow? What does that mean for me? Is that like a C Corp? Is it like an LLC? What exactly is that? So yes, it is a type of business model like a C Corp, like a partnership. Some states even have benefit LLCs. When you're incorporating in a state, you would choose to be incorporated as a benefit corporation. And if you do that from the outset, then there's a particular process to what you have to do. It has to be inside your incorporating documents. This is what we are. These are our expressly stated public values or specific benefits to the public. And there has to be some sort of auditing mechanism where you publish what you're doing and how you're doing it. And if you think about that just from a practical standpoint, that makes sense. You have to walk the walk, right? So if you're saying, okay, I want to grow my company in a way where I can continue to do this kind of stuff. Downstream investors can't sue me, get rid of me, whatever, because of the things I care about, then it can't just be talk. You have to actually show and open your books to some extent to inform the public that this is what you're doing. As I mentioned, 40 states have adopted benefit corporation statutes now. They're not all the same. Some of them are what I like to call benefit corporation light. They're not exactly triple bottom line type of business models where you're taking into account all of your stakeholders, what you're doing for the public, the environment, In Tennessee, it's more of like a social purpose statute where you can kind of call out one particular thing that you really care about, and that's the only thing that you have to really operate according to in terms of showing that you value this in your business decisions. It could be a religious thing, it could be an environmental thing. So some of these states, the teeth are not as sharp as in other states. So keep that in mind. And what's really driving this is millennials. They want to work in some sort of environment where they feel like they're accomplishing something, they're part of something. The reality is no business is going to leave the world in a better place, so to speak, than the way it starts. There's always going to be a taking and a consumption to any organized enterprise. But people care now. The younger generation cares about where they work. They want to know that they're doing something that matters. And this matters to our economy. You get to retain top talent, attract capital investment, and studies out of CBEY itself show that your company can have better legs compared to your peers, can be better positioned for investment. So there's this sort of myth that's out there that, oh, if you do that liberal kind of stuff, we hear this in the South a lot, you're never going to grow. Nobody's going to invest in you. Nobody's going to do stuff like that. But there's really good data out there that dispels that notion. And yes, I see the comment a little bit triple versus double bottom line. So I absolutely can get into that. So there's not a lot of litigation out there around benefit corps. And that's concerning to some extent for me and other attorneys who practice in this space. Here's one example of where you might see how a dispute arises. In this case, you basically had a company that was operating as a benefit corporation. Its board of directors, to incentivize directors to actually participate, decided, well, they wanted to pay directors just a stipend, really. I mean, $1,000 a quarter in the grand scheme of things is not a lot. And that led to a dispute and litigation. And so that's, for that to be a primary example that people are citing in terms of how benefit corps are litigated, it tells us that there's really just not a lot out there. So what we're advising is really based upon the statutes. I mean, in some sense, it's good. It means that the statutes are working. There's not a lot of litigation around this. There's not a lot of need for people to challenge these benefit corporations. The investors who are participating in these benefit corps seem to be happy with how things are going. That's a generalization, but it's a good thing in some ways that you don't see a lot of litigation. But it also doesn't tell us a lot about, will these different statutes ultimately hold up? Are some more likely to sustain challenge than others? And what various degrees and wrinkles do you have to have? An example of what shareholder primacy is all about is I just cited in here a couple of companies we're all familiar with, eBay and Craigslist. So eBay, upon coming on as an investor into Craigslist, decided that Craigslist needed to start charging for some things. And so a dispute arose around whether Craigslist could kind of keep its core corporate culture and offer their services for free. And eBay brought a suit for breach of fiduciary duty around that. And this is one of those cases that shows that shareholder primacy does actually have some teeth. It matters what you're doing. It matters who your investors are and whether they're getting the benefit of their bargain and their investment into your company. So a personal example, Ben kind of teed this up. So I have started a number of tech companies, been a co-founder in some more medical advice, small molecule type companies. I also co-founded a company called Turd-Cules. So Turd-Cules now is a man's toilet spray product. Initially, we started this company out, me and my co-founders, actually with a social purpose. We started the company to provide a subscription-based model for septic system cleaners, kind of a drop one in the toilet once a month. It'll keep your septic system clean. You don't have to use nasty stuff like, unmentionable sprays that a lot of people use and buy at stores like Dollar General. And we were hoping to disrupt that market a little bit. In the rural South and other places, there are a lot of people on septic systems instead of on city sewer. And if they don't properly maintain those systems, it can back up. It can be a huge, huge plumbing bill that families can't afford. So we identified a market space to try and introduce some, kind of updated business model to. That didn't really go anywhere. But our shtick was appealing to some investors, the Turkules, some of the funny names, the funny things that we did. And they decided that they wanted to turn that into more of a men's toilet spray type of product offering. And so now we're doing that, it's growing. But that's all to say that we at least had a good working relationship with those investors. And we were able to do that. We were able to split out that core idea of the one-to-one. We're going to donate some product to rural areas in Appalachia. As we grow this Turkules business, we were able to regroup, spin that out as a different idea, and pivot according to where the company needed to go to make money. If that had been a hostile relationship with our investors, and we were not a benefit corporation, a benefit LLC, then those investors could have trumped us, and they could have made our lives very, very difficult. And that's just kind of one example of, personal example I have of being in the founder seat versus investors, and how you are trying to grow and develop a mission-oriented business. So now I'm going to get into a little bit of B Corp. There's a lot of overlap between the concept of B Corp and benefit company or benefit LLC or benefit corporation. There's a lot of confusion out there. So I just want to kind of run through some things. And these are all slides from B Lab. So I'm just going to kind of hit these at a high level. B Corporation, this is a business designation as compared to a legal designation of a benefit company. So if you're a benefit company, you're a legal entity. And as part of your requirement, your ongoing requirement as a benefit company, you needed to be audited on usually an annual basis. So this is really where B Lab and the B Corporation designation sort of rose to fame as the primary auditor for a lot of benefit companies. B Lab provides this B Corporation certification. So if you run your business according to a verifiable triple bottom line model, then you can get this stamp of approval. And that will satisfy a lot of these benefit company statutes. So B Corporation is really a trade designation, kind of like you might think of fair trade or LEED. It's a trust mark, and we'll talk a little bit about trust marks and what that's all about. So a lot of companies out there are certified B Corps now, a lot of big companies, household names that you recognize. And it's about companies who want to demonstrate to the public that they're trying to build a better world. You hear things like using business as a force for good. These are common sayings and phrases and marketing that you get from a lot of B Corps. How does a company become certified? Really, it's about a testing and auditing type of process. So you can't just start your company tomorrow and become a B Corp the next day. You have to have some data to show B Lab to prove that you're operating your company as you say you are according to the survey and the impact assessment. And so you really need a year of data. So I typically tell clients or contacts who are interested in B Corp certification that if they're just starting up, they can earn sort of a B pending designation, but it's going to be over a year before they can say that they are officially a certified B Corp. But it really helps to take the impact assessment on the front end. This is a publicly available test. You can get an idea of where you stand. And as you grow, things you need to think about, things you want to take into account, like, well, if buying local is important, then how do I do that? You know, how do I engage in the community in a way that meets the B Corp standard? What are some different employee policies or ways to deal with my employees that are important for this B Corp certification? And so it's a really great tool at the outset of founding your company to understand what are some good ways to just grow your company as a true social enterprise. Now, this is pretty much product and service agnostic. So again, back to that example of, hey, the solar company, we're doing great for the world. We're varying the energy portfolio. We're helping solve against climate change. We do good stuff. So can't we just be a B Corp because we do good stuff? No, the B Corp designation is really about how you are taking into account all your stakeholders, your employees, your shareholders, your community, the environment. All of these things go into your assessment. And so it's really a holistic framework. And so when you see somebody's B impact report, you'll see it's broken down according to the community, its governance structure, environment, what's the supply chain like? For some companies, it's a lot harder to address some of these questions than others. If you're in the software space or you're using a lot of cloud services, well, how do you really evaluate your supply chain in the same way as if you're selling something on the grocery store shelf? So the good thing about B Lab is they're responding well to those concerns and that feedback. And so they actually have a number of different types of evaluation models for different types of companies. So it's not really just a one size fits all type of box that they're trying to put everybody through. So just a couple things similar to benefit corporations. What do I get out of this? It's a verifiable, time-tested stamp. It's not perfect, but a lot of the companies that you believe in use this designation. They believe in it. They support it. It's not greenwashing. You really have to have somebody kind of come in. You have to open your books. You have to show, hey, this is what I'm doing. This is what I care about. It's important to me. It's going to take you some time to do that. You're going to spend a lot of time at the outset trying to frame your operations according to being able to work with these auditing reports. But on the back end, you get a lot of credibility. So some of the pros of B Corp certification and cons of B Corp certification. As the CBEY reports show, there are companies that do a lot better as B Corps, as benefit corporations compared to their peers. And I can personally attest to these things. I have attorneys who've come into our firm who want a culture change, who are tired of working 2,500 billable hours, not seeing daylight. They want to work in a place where they feel valued, they have room to grow, to develop professionally, and work on the types of projects they like, and work for a place that they know takes into account the environment, the community, social movements that advocate for things that that are important in the world. And so the talent attraction and retention thing is one of the top things that I would say, is being able to get really super talent in that way. Some of the cons are just the time and resource commitments, potential sacrifice of near-term profits, and the high levels of scrutiny. Now, these may be reasons that you don't want to pursue a B Corp certification. Maybe you want to just incorporate as a benefit corporation, where really there is a little bit less public exposure to what you're doing. You could still maybe market yourself as a public benefit corporation, depending upon if you're B2B, B2C, B2 government. You know, that may be all you need in terms of from your business development operational standpoint. But the B Corp certification really is a little bit more strenuous and taxing. And a little bit more along those lines of why this is important. We all are aware of the age that we're in with COVID, what it's doing to retail. Here's some articles I threw up there. E-commerce, digital footprints are extremely, extremely important. And so trust marks, which is basically what the B Corp designation is, these are ways to distinguish you, your company, what you're doing to potential consumers, to potential partners. Do they want to do business with you? And they can look to this trust mark as, okay, yeah, they're credible for these particular things that I care about. And this is a great report here that I reference, Trustmark Strategy for Exploiting Their Full Potential in E-commerce. Check that out. You can see what the empirical data says about consumers who are shopping online and how they differentiate companies that have trust marks versus those that don't. And some takeaways from that report. So I recommend that you check that out. All right, so that's my run through of benefit corporations versus B Corps. Okay, so there's a distinction, a legal versus a business distinction. You can choose both, or you can choose one or the other. You can be a B Corp, particularly if you're in a state that does not necessarily have a strong benefit corporation legal statute. You can be a B Corp without incorporating under that statute. You can be a B Corp as an LLC. You can be a B Corp as a sole proprietor. So you don't necessarily have to be operating in any sort of statutory framework to be a B Corp. So just to kind of break those out, those are a couple models around social enterprise on the legal side. And now, since I'm here, I'm a patent attorney, I'm going to run through some different aspects of IP. And then I see some chat questions. I'm going to get to those very shortly. So we'll have plenty of time for Q&A after this. So please do feel free to still pop these in the chat because I'd love to know just kind of what you're thinking, what your questions are. All right, so the intellectual property environment that we're in right now, if you're doing business online, then there's a lot of stuff out there that you probably don't think about that I deal with on a daily basis. So copyright trolls. One thing that you may or may not know, you may have heard of patent trolls, but we have a huge rise in copyright trolls. So if you are building a website and you're taking some pictures that you got online and maybe you're getting them from some site where you think it's open source, I can use all these pictures freely. I like to think of open source as sort of Baskin Robbins, 31 flavors of open source. Just because something's open source doesn't mean use it however you want to and don't report to anybody or recognize anybody. So we are seeing a lot of small businesses who these copyright trolls are going after them and filing federal complaints against them because there's a generic picture on their website. And so when you talk about the dollars and cents of litigation, what you have here are holding companies that acquire copyrights. Maybe they're pictures from family estates. Maybe they act just in the same way as patent trolls do. They can acquire copyright rights and then they'll go after people. And the firms that they hire to do that usually get a commission. So you'll see this and they use the same federal complaint over and over and over. So it doesn't really cost them anything. They're incentivized to do this. And if you're on the receiving end of that, then you've got to choose, okay, do I pay you the $5,000 that you are demanding from me? Or do I go pay a lawyer down the street a minimum of $10,000 just to engage in this? So be aware, this happens not only in the website space, happens in the music space. If you're a bar owner, you've got an open mic night and somebody that you don't even know comes and plays a song that is held by one of the publishing houses, and you've got somebody in there who their whole job is to see if there's any music that's played in your environment, whether it's live music or sound system music that comes from their portfolio, they're going to hit you with a lawsuit or a demand for $20,000, $70,000, $150,000. I'm seeing this time and time again now, very, very frequently. So you're seeing a lot of bullying in the copyright space, in the trademark space, just a lot of stuff around e-commerce that you may not be thinking of, but it's a very, very active space. You really got to do your due diligence in how you are developing something, how you're building something. And recently did a presentation around open source vulnerabilities and security issues. So if you're building tech using some open source building blocks that you got off GitHub, then you may be setting yourself up for GDPR violations. So there's a lot of stuff that you need to be concerned about in the IP space. That's not just the, oh yeah, I know what a patent is versus I know what a trademark is. So when we first meet with clients to talk about, hey, you're doing an e-commerce business, say for instance, these are some of the questions that we go through. Basic things, but what's the difference between a copyright and a trademark? What might be infringing? What do I care about? And how am I going to be selling something, my services or my products? Am I going to be doing this direct to customer? Am I using a platform like an Amazon, like an Etsy, like Google? How can I protect myself in those spaces? Am I going to be bringing things in from overseas? We had a client a couple of years ago who was buying some well-known type of insulated mugs via Alibaba from the exact same manufacturer in China that made them for the actual company that owned all of the trademarks. And he was bringing them to the US and did quite a volume selling at flea markets. But US Customs ultimately came down on him, and that's the type of protection that you can have if you have some registered copyrights, some registered trademarks, a good program around IP. So I'll just kind of get into what are some fundamentals about IP. All right, so it's really not intellectual. I think we need to strip that out of it. This is old hat. It's all just derivative of property rights. Ancient Romans, ancient Venetians, ancient Brits were all practicing some form of intellectual property. It's all about, I have stuff, you can't take my stuff away from me without my permission. And that's all it is. It's not about the mind necessarily. Sometimes you can have an intellectual property right without actually producing something. You see this in the patent space a lot. If you have something so conceived in your mind that you could explain it to somebody else and they could go and practice it without a lot of innovation, then you have a protectable concept there. So it's not necessarily about the mind. It is about property. I like to use a backyard as an example that everybody kind of understands. What's going on with intellectual property is you have your backyard. At some point, that yard was surveyed to identify what are your boundaries in your backyard. It's up to you to build a fence to keep people out, to keep some sort of monitoring system in place so that somebody does not come onto your property without permission, without whatever you want to negotiate in terms of your monetary compensation for coming into your space. And that's what the intellectual property right is it's some sort of recognition of your boundary and your space and your right to exclude people from entering into that space, whether it's a copyright, trademark, or patent. We all kind of, I think, conceptually understand the differences between these. Copyrights are usually around something that's visual, that's creative, and trademark is a source identifier. It's around a logo, a slogan, a smell, all kinds of things that really act as source identifiers. Patents are usually for the widgets of our lives. And the trade secrets, it's the KFC recipe, right? That's trapped, I wouldn't say trapped, that's locked up in a vault with lasers around it. So, sometimes it's about, well, we can't patent this, so how do we protect it? And if we layer enough protections to our secret sauce and how we organize and operate our business and deal with supply chains, then we can have a protectable right there that's just the same as a copyright, trademark, or patent, and goes on indefinitely. So it can be even more valuable in some ways. So at the outset, we're talking about what's your baby. Up top here, we've got one of my favorite patents of recent memory. So this is, if you've got an autonomous vehicle and it hits a person and the person flies off into a telephone pole, that's not a good thing, right? So how do we address that? Well, we can make the hood of the car sticky. And that way, when our autonomous vehicle hits somebody, they don't fly into the telephone pole, they just flatten on the top of our car and they're just gonna stay there, all right? So this is a Google patent, shocking. And so, this is what a patent looks like. I mean, what's a process that we're trying to protect? What's a system? What's some sort of embodiment that we want to protect? We have copyrights there, Kendrick Lamar, something very, very graphic and visceral and creative. And we've got all kinds of layers of copyright protection there. Something can go multiple ways. It could be patentable, it could be trademarkable, it could be copyrightable. So you can have layers and layers of IP. Trademark protects your brand. It's your source identifier. It's your name, logo, slogan, sensory designs. It's not going to extend to what I call mad marks, geographic marks, shotgun marks. What's neat about the trademark system is you can come up with a good name for a product, and you can go ahead and file an application on that name, even though you're not going to roll out any product around that for 6 months to a year to 2 years to up to 3 years. So you can kind of call shotgun on it, but eventually you have to show that you're using that mark in commerce because your rights are developed through use. Looking at the trademark database is actually a really good way to spy on your competitors. It's not really spying because it's public, but not enough companies do that. Not enough companies are monitoring what new trademark applications are my competitors filing? When they file that application, it's immediately public. So you can see, oh, what are they doing here? It looks like they're starting to get into a certain line of products, or they're starting to go into a kind of a different type of marketing strategy here. So it's a great way to just keep an eye on where are your competitors going many, many months before you actually see it out there in the public. I mentioned it's a source identifier. You've got a statute around it, what it's all about. You can trademark a lot of things. A lot of different aspects around what do people think of when they think of my company, when they think of this product, when they think of some visual packaging. What is it? Does it go back to a company? What kind of level of credibility does it have? You can protect all of that. Here are some examples of ours. We got our business name, we got a slogan, we got acronyms. So all these types of things you can protect. Who trademarks out there? This is kind of fun. You can kind of see lots of different types of companies trademark. And what's interesting about this just sort of landscape overview here is that really conservative companies trademark a lot. And if you think about why that is, they're in tried and true business models. You know what that company does. They've been around. Banking. Oh, how exciting is banking? Well, you can make it exciting by constantly rolling out new features and new marketing campaigns and new strategies. So you might see a really, really, really active space in a very conservative traditional industry. Don't use these names. It's a bad idea to use any of these names. And it surprises me, and people still use things like best and try and file a trademark application on it, all right? The fact that there are 21,000 filings in the database says that's not a good thing. It's not really a good source identifier. Not gonna get you very, I like to think about trademarks from an EQ perspective, rad versus sad versus mad trademarks. So your random, arbitrary, disconnected trademarks, your Google for PageRank, your Amazon for an online shopping place, your Uber for car share service. What is that's completely random. And the reason why they end up being such strong trademarks is if you see that name associated with any disconnected product, you're going to think that's company is behind it. So if you go to a store and you see a microwave and it's a Google microwave, you're automatically going to associate that with the company Google. And that's why those marks are so great. It's really hard to get companies to go for something random. They don't like it. They want to have, in fact, companies, entrepreneurs and founders are more willing to do it, but their design firms are less willing to do it. The design firms want something that they can show is more of a suggestive type of mark. It's creative, but it still shows what you do. Those are good for ad campaigns. Those are good for online marketing. And so there's a disconnect there sometimes between what's going to get you the strongest trademark protection versus maybe what's going to help you grow at the outset. Maybe you need a little bit more suggestion as to what does your company do exactly. If it's just super accurate, Paul's Popsicles, you're not going to get a trademark on that. And nowadays you won't, maybe some time ago. So when you think about trademark, this is really the law of confusion. All right, so if there's a confusion to source, is Mountain Dew made by PepsiCo, to relationship, well, I guess they signed off on a parody, to dilution. Yeah, this stuff is bad. I'm not dealing with anything that has that kind of name in it again. So if you've got a competitor out there that's causing confusion with your company, your relationships, maybe it's an upstart, maybe it sells, or my French, a half-assed version of what you're doing. That's going to be dilution. That's going to be trademark infringement. So that's where your trademark protection is. It's in, how are people embracing what you're doing? There's a difference between copyright and trademark. Trademark can go on indefinitely. Copyright, thanks to Disney, goes on almost indefinitely. Life plus 70 years, goes on a long time. They have different rights. They have different ways they work. From a litigator standpoint, I love overlapping protections because you have just a lot of different options in terms of if you need to go after somebody, if you need to enforce rights. And the reason why you're seeing a lot of those copyright trolls is because we have a system of minimum statutory damages in federal court around copyright. So if you have a registered copyright and you file a federal suit against somebody, you not only have to prove that somebody has violated your copyright, but you have to prove damages. If you have a registered copyright, there are some minimums. It's kind of like saying, well, you don't have to actually prove that you lost a bunch of money. We're just going to automatically grant you this level of damages. Whereas with trademark, with patent law, with some of these other areas of law, you have to prove, well, I actually suffered something that I can show in pretty concrete terms, but for their infringement, I would have had this market opportunity. I would have had this income. And so that's where copyright can be really, really powerful and why you're seeing a lot of manipulators around that. What does it apply to? It applies to all the creative stuff you think about. It also applies to organization of data. So a lot of companies who are in this sort of med health space, biometric space, there can be a lot of protection you can get around organization of data. You see a lot of activity. In the old days, you actually saw companies going after one another for infringing phone book designs, or those little forms that you fill out on paper when you go to an outpatient medical provider. A lot of different companies copyrighted those and they fight about it. Well, now you got that in the digital space. So, oh yeah, somebody hands you an iPad and you fill out some information on that. The organization of those data entries can be protected, and you can assert those against others. The skins of your app, your GUIs, all these different things have some copyright value to them. So pulling out the distinctions between what's factual information versus what's your organization of that factual information is really important. And there are US laws and international laws. So let's say you're a biotech company, you're dealing with a lot of bioinformatics. Well, these laws don't exactly match up in US versus other places. In other places, you might actually be able to get protection around the raw bioinformatics information, whereas in the US you can't. So just knowing that these that laws don't always mesh well. Kind of already talked about the copyright trolls. Just some examples of what is copyrightable, the things you always think about, the creative things. These are all copyrightable. Lots of things can be copyrightable. It's easy. It's the cheapest form of intellectual property protection. But again, you have to enforce it. You can easily build that fence, but you got to monitor against it. Patents are the sort of widgety things, right? So the things that accomplish something. It's some sort of process. It can be some sort of external design. We're seeing an explosion in design patent filings and registrations, and it's because you can actually, in some ways, capture functionality in how something is designed and how it looks on the outside to people. And so you have a lot of activity in that space. The patent system is way backlogged. So in the US, we're actually receiving more Chinese applications entering into the US than we are seeing by US filers. So crazy backlog system. With a design patent, you can get through a lot faster, and oftentimes you can get an issued design patent within a matter of months. The challenge is it's easier to work around. So these things can be overlapping protections in terms of your utility and your design patents. I won't get into some of the stuff you may have heard of. If you're active in this space, you've acquired patents before, maybe you're dealing with some nuances in patent law around some of the hurdles to getting a patent. Maybe it's what we like to talk about in terms of obviousness. There's a lot of prior art out there. An examiner is combining different things that he or she found all across the world and saying, voila, I've put these 5 reference points together and that's just your invention. That's actually pretty common. It's probably over 90% of applications get obviousness rejection. So you can work with your patent attorney to deal with that on the front end, anticipating that you're going to get that kind of rejection, but thinking about how to overcome that. Have you made an adequate disclosure? If you want to hold something back because it's truly secret sauce, then you may run into some issues with patentability about how you adequately disclose this. Natural phenomena, this is something in the last 10, 15 years. It's affecting the software space. It's affecting the biotech space, business method space, fintech space. Basically, the idea is what you've developed, that's really just, it's already out there. It's a known concept. All you're doing is automating that. An example would be, you want to watch a YouTube video and you're going to get a commercial that pops up. Well, 15 years ago, that was patentable. That idea that something pops up, you got to watch a little promotion, some advertising comment before you can actually watch what you're there to watch. Those patents were invalidated along these lines. Basically, it's just natural phenomena. This concept is nothing new. We do this in radio, we do this in TV, we do this in newspapers. But the way you do that, if it's a technical solution to a technical problem, can be protectable. So there are some real nuances there in terms of what you can protect in your technology. Again, the feds, they're surveyors and they're not fencers. You got to build your fence. When it comes down to patents, it's really all about your claim set. You might come across somebody's patent. It's 300 pages of a description of what this thing is. What's really, really important at the end of the day, if you're looking at, do I have freedom to operate against this patent, is what the claim set says. And words are extremely, extremely important. I like to use an example of a chair. Let's say you got a 3-legged chair. All right, so somebody's got a patent on a 3-legged chair. You come along with a 4-legged chair. All right, you find a lot of people really like that 4-legged chair better. It's much better for many, many reasons. Am I going to infringe the 3-legged patent if I start producing this 4-legged chair for the market space? And that can turn on whether in the claim set there is the use of a word consisting of 3 legs versus comprising 3 legs. So claims matter. Sometimes you use a word, it can capture not only what you've described, but anything else that's thrown in there that's unanticipated at this moment. And that's where you get into comprising, versus it can be very, very limited with like a consistent type of language. So it's really, really important if you're developing something and it's a really competitive market, you know about some publications by your competitors, you know they've got some patent filings out there. You really want to look into what are their patent claim sets, how much freedom to operate do I have around their patents, and can I get patents above their patents? So it's a really nuanced process to take a look at that and investigate that. All right, so we're at an hour. I'm going to finish up with some tips here just around social enterprise and scaling according to social enterprises. So one thing I'll say is pivot with purpose. Every company's got to pivot at some point. Your original ideas are going to change. The market's going to change on you. We are right now in an age where you've got a lot of companies who they've been out there for 3-4 years, pretty stagnant market. All of a sudden, COVID comes along, and you've got a virtual workforce, and there's crazy demand for their products because it's around virtual teaming or interfacing or productivity tools. And all of a sudden the market is exploding for them. So you're always gonna have to pivot according to what you do. But you wanna pivot with purpose, all right? So let's say you're one of these companies where the market has just exploded for you, okay? Do you want to stack your company? Maybe you get some cash flow in to go after this market, take advantage of it. Do you want to stack your company with a bunch of sellers who can close those accounts, close subscriptions, some technology that can close subscriptions, and maybe you have some good contracts on the back end that are going to protect from people canceling those contracts and subscriptions, getting any money back, but maybe you don't have any money left for support or technical services. So what do? You know, maybe you choose one versus the other. Maybe you make some sacrifices, but your culture is going to be defined by the decisions you make when you need to pivot. So keep that in mind, just pivoting with purpose. Understand who works for who. I really like Brad Feld and all of his work. And he makes really great points around you are the entrepreneur, you're the founder, your lawyers, your investors, everybody works for you. Get partners who you know care about you, who champion you. If you're going with a venture firm, choose the firm where the person who's going to sit on your board is an active participant. Choose the group that's going to mentor you, that's really going to help you succeed. And in my experience, you tend to find many, many more actively engaged investors in the social enterprise space. Leave the organics to Whole Foods. I see so many companies who they have gotten to a certain point of success on handshakes because the early founders, they wanted to keep it all lovey-dovey and organic. And then a problem arises and we have no idea what to do because there's no documentation, no agreements, no structure around the company. Even if it's on a napkin, you know, this is what we want our company to look like. Write it down on a napkin. Get something in writing. Get some perspective around what are your relationships among your founders, who's expected to do what. Even in your early business ventures and your business partners, make sure that you're getting some structure there. It's just a professional, responsible thing to do. Value the front end and virtue the back end. When it comes to social enterprise, when it comes to those trust marks, in my experience, ultimately your customers are going to purchase your product because the value it offers, the service you offer, they demand that because they can utilize it. But your virtue helps to keep them at the table, to keep them as customers. It helps to share in those networks. Your customers will tell others, hey, you offer a really great product or service and you're a really awesome company. So those trust marks, they're important to have and to use strategically as back-end devices. The SEC is not just a football league. Too many founders shoot from the hip when it comes to the securities regulations around how you can deal with investors, how you can deal shares, promises, equity, even your friends and family type of rounds. It is really, really important to have some guidance on this on the front end. A lot of these SEC regulations are set up for the benefits of investors. All right, so if you are using a broker, for instance, to try and get you some money, and you've incentivized them in some way, and they're not a registered broker, they're going to be less likely to disclose that to investors that they are seeking. That can get you into real hot water. That's just one example of the myriad SEC regulations that concern what you're doing. So really think through, even your pitches. Even your pitches can be construed as public disclosures in a way that you are fundraising that may fall outside of SEC norms. And finally, you're in a safe, risk-tolerant place. When I worked for UC Berkeley a few years back, we would have a number of delegations come in from all over the world who all wanted to know, how can we do Silicon Valley in our country? And what I often found was their countries and their business cultures were extremely risk averse. You may, in the US, see a founder who's been successful that has failed 5 previous times. And we're in a risk tolerant place. So even if the company that you founded is not ultimately successful, you can learn a lot and you can still develop your next company. And so just keep that in mind. Don't beat yourself up too much. You have the opportunity in the US investor climate to fail, learn some things, and be a better founder or developer the next time around. So that's it for me. And I did take a little over an hour. I apologize for that. But just to kind of hit on some of the different things that I'm seeing, wanted to give you just kind of a high-level overview of some different IP, benefit corporations, some things that I've seen, experienced personally. And I can kind of go through what I see here in the chat space and hit a few of these. And I think Ben may come online here too as well.
Yeah, just wanted to say thank you, Kevin, for that overview. Just in light of things being virtual now, we recognize that you've got a bit of Zoom fatigue. So I wanted to keep the main content to an hour, but Kevin has graciously offered to stay on a little bit later to answer any questions. So we're going to stay on the line here to answer questions and address some of the good questions, some of the funny questions that came out on the chat, as well as anything else you might have. But those of you who need to go, please feel free to do so. And thank you all so much for being here and joining our first Innovators Toolkit session. Check out the Innovators Toolkit website, which will also go out in a follow-up email for subsequent sessions over the course of the semester. I think there's at least 7 or 8 of them. So definitely check that out and continue to stay connected to CBEY and CITY. So again, thank you all for being here. Kevin is going to stay on the line to address your follow-up questions. But if you do need to head out now, please feel free.
Thank you, everybody. So let me scroll up here. So I've got, okay, so I'm just going to kind of scroll up as we go. So for those of us who plan to blitz a marketplace and wish to protect our trademarks and copyrights internationally, any tips or considerations as we go about this as a benefit corp? So when you say blitz a marketplace, I'm not really sure what that means. But I wouldn't really say that your trademark or your copyright strategy needs to be unique to your benefit corp status. So if you're thinking in terms of being very, very aggressive with your copyrights and trademarks, just remember that we are in a world of socially sharing everything. And so we actually defended this recently. We had a company out of California, my firm, that opposed one of our trademark applications. And I took it as an opportunity to humorously respond with a little instruction of what to do when you get a cease and desist letter. So just remember that you're dealing with people who may share something that's improperly worded that can ultimately harm your culture or the perception of your company. But other than that, I mean, there are companies that you would never think of as being really aggressive with their trademarks. AARP is one example. This is a nonprofit that derives about $1 billion a year in licensing revenue out of their trademarks, and they are fairly aggressive with their trademarks. So, you know, you can still be an enforcer with your IP, even as a benefit corp. Just remember to do it in a way that doesn't come back to haunt you. Okay, I'm going to continue to scroll up here. How does pedos stack up against Cheetos in the context of what you're sharing? So when it comes to confusion, if pedos is selling the same kind of product as Cheetos, then there are potential grounds for infringement. I would say that if the intent is to confuse about a relationship, there's an opportunity for someone to litigate over it. And also, there's not a lot of actual court trademark litigation out there. There is an administrative system, TTAB, and that is the system where if you are wanting to cancel somebody's trademark, for instance, you go through TTAB. If you are wanting to oppose someone's active trademark application, you go through TTAB. It's kind of a quasi-administrative litigation. And there is where all the activity is when you're talking about trademark bullies and issues around infringement. It's very rare that companies actually file federal suits in the trademark space because it's very, very difficult to prove damages and infringement in court. So it's not nearly as active as copyright and patent. But if someone is trying to get a PEDOS trademark application, I can almost guarantee that whoever owns Cheetos is going to file some oppositions against them. Let's see, permission to use these images. I think everything in here we developed on our own, so I'll double check that. Finding it difficult to balance these IP considerations with a desire for socially impactful and circular economy principles and solutions to be widely accessible and extendable. I don't know exactly what you mean there. If you're saying that if you want to advance a holistic company, then being aggressive with IP or even choosing to lock up something is problematic. To some extent, I can absolutely agree with you. So let me take an example in the pharmaceutical space. The average drug costs, well, a tough study a few years back estimated it at, I think, $2.4 billion to take something from bench to market. And part of the reason why drugs cost so much to consumers is because of the patent system. So you have a very long regulatory road to get to market. And so by the time you do get FDA approval, after you've gone through all your clinical trials and your development process, you usually only have a few years of IP protection left. Now, there are ways to kind of manipulate and create families of patents, but generally speaking, you only have a handful of years before your competitors are going to be able to compete with you using the same molecular design. So that's why things are priced so egregiously sometimes, is to recapture that ROI from what was invested. And so in that sense, patents can be problems for society. But then again, if it costs so much to invest in developing a drug, then that patent protection is almost necessary to make sure that you're not going to invest all that money and somebody else is just going to come along and exploit what you've done. So that's, that's my response to that. But I think you can protect your intellectual assets in a meaningful way, in a way that even B Lab, a lot of the different marks that B Lab has are trademarked, and there are usually pretty significant protections put in place for trust marks like a B Corp designation. Let's see. EFF, Electronic Frontier Foundation. So they do some great work advocating for, say, for instance, privacy rights. Let's say, for example, well, that privacy is just a field that everybody's quickly learning pertains to them. Any kind of company that you have with rollout of European and California legislation. So EFF is pretty active in that privacy space, allowing you to protect your information, to protect your ability to safeguard your information, or to engage in free speech online. So great organization. Check them out. So let's see. Capture a couple of these on the back end. I think maybe Ben, I have everything. Are you still online?
Yep, I'm still online. I think you covered everything. I mean, if anyone has a question that has not been addressed yet, feel free to put that forward. Did you get to the Zebras Unite question?
No, I didn't see that. Can you read that one to me?
Are you involved with Zebras Unite at all? Do you know that movement?
I don't. So please, please send me anything on that. So I'm gonna, for the questions I didn't get to, just so everybody has it, I think that's distributed to everybody, but my email address, you can also find my Calendly page on my website. There's a section in my Calendly for just getting to know one another, 15, 20 minutes just to say hi. You're in a similar space. I love mentoring. I'm an old man at this point. I've got 3 kids. I can't ride my bike as fast as I used to. So people who are out there as entrepreneurs, driving things, innovating things, I just love engaging with. It teaches me a lot about my practice, helps me to be a better lawyer. So I'm always interested in talking and chatting and getting to know you a little bit.
Great. Well, Kevin, thank you so much for making yourself so open and available, for sharing so much information. Thank you to the dedicated few who stuck around for a little bit of Q&A at the end here. As I've alluded, I will be sending out a follow-up email with the slides, with the recording, with some of the links that we've been sharing in the chat, and with Kevin's email, so anyone can follow up with him there. So thank you all for joining. I think we're good to wrap up. Thank you again, Kevin, for joining us and for that great overview of so many different concepts. And yeah, those of you still around, check out more Innovators Toolkit.
Thanks, everybody. Bye.
All right, take care, everyone.